So good afternoon. I'm Heather Hughes, and I appreciate you taking the time to join us today for our Partnering for Success webinar series. Today, we will be discussing mutual aid versus interlocal agreements. We will be recording today's webinar and distributing to each of you. As we progress through the presentation, please feel free to put any questions you may have in the chat box. Our presenter today is encouraging everyone to ask questions, and we will interrupt her as those questions come in to keep them timely and current. Our presenter today is attorney with Farrer & Bates, LLP, Kristen Berexa. Kristen joined Farrer & Bates in 1994. Her areas of practice include civil rights defense, law enforcement liability defense, municipal liability defense, and employment law. Over the years, Kristen has handled a broad range of cases involving complex constitutional issues, police misconduct, officer-involved shootings, catastrophic accidents, and employment-related matters. Prior to joining the firm, Kristen served as an assistant attorney general for the state of Tennessee Office of the Attorney General. Kristen received her law degree from the University of Tennessee College of Law in 1991, where she graduated cum laude. She received her Bachelor of Science degree in psychology cum laude from Austin Peay State University in 1988. In addition to practicing law, Kristen provides training seminars for her clients in all aspects of law enforcement liability and employer-employee relations. She has been a featured professional speaker at conferences on topics of municipal liability, police liability, and employment law. In addition, she has been named to the Mid-South Super Lawyers. So without further ado, I give you Kristen Berexa this time.
Thank you, Heather. I appreciate that introduction, and it's really starting to show my age as well, giving the 1988-1991 graduation dates. I just want to thank everyone for joining in the webinar today. I know at least here in Middle Tennessee, it is a very dreary Thursday afternoon, but I'm going to do my best to sort of keep everyone awake, and hopefully we'll get enough questions that this will be, even though we're not in person, it will be an interactive seminar. Just to start with, I want to talk about, I guess I'm just going to jump right in. And I want to talk about mutual aid and assistance. Now, that is a huge, broad category. And in order to really understand that, you really need to break it down into the various statutes that are used to govern what we would call mutual aid and assistance, or for my purposes, I consider that to be just the sharing of governmental, particularly law enforcement resources. So under that sort of broad category or definition of mutual aid, we have three different statutes that apply to mutual aid and assistance. We've got the Interlocal Cooperation Act. And if you'll notice, I put some abbreviations here because sometimes the words mutual aid get a little confusing as to which act or statute we're talking about, or if we're just talking about generally mutual aid. So for purposes of the webinar, this Interlocal Cooperation Act, I'm going to refer to as the ICA. This is a very broad statute. It is really just an enabling statute. There's no real substance to it. It just allows governmental entities to cooperate with each other to their mutual advantage. So the ICA can apply to law enforcement, it can apply to public works, it can apply to maybe a nonprofit company or corporation you're working with. It's just a broad act that covers any sort of cooperative action or agreement between governmental entities and some nonprofits. And then underneath the ICA, you've got two other acts that both have mutual aid in their title. And I think this is one of the reasons there's been some confusion over the years when we refer to mutual aid agreements. The Mutual Aid Agreement Act, as I've referred to as the MAA, can be found at 10 Codan 654-307, and it is specific to law enforcement. It allows police officers to answer calls outside their jurisdiction and perform duties in that jurisdiction as if they were functioning in their own jurisdiction. That's the specific intent of that act. So that act would cover a broad range of law enforcement activities. The Interlocal, the ICA Act and the Mutual Aid Agreement Act, again, cover broad types of sharing of resources with law enforcement. Then you have this other act that's called, again, Mutual Aid in the title, Mutual Aid and Emergency and Disaster Assistance Agreement Act. That is a mouthful. And I think the easiest way for all of us to distinguish between these statutes is if we refer to the Emergency Disaster Assistance Agreement Act as just that, EDAAA, or let's just leave out the mutual aid. So there's no confusion between the two statutes. And I'm going to get into here in just a minute as to the difference between the two and how the EDAAA is very limited in scope, unlike the mutual aid agreement and the ICA. And in putting together this PowerPoint, loss control guidelines, and some other agreements I'm working on drafting, I have talked to and worked with Judy Housley on this, and the people from MTAS, David Moore, Rex Barton, and even some of their attorneys. So at a basic level, I think we all agree on what this EDAAA, Emergency Disaster Act for short, applies to versus what an interlocal agreement or mutual aid agreement is for. Now, that doesn't mean we all agree on what needs to go in the written agreements themselves, but I know for many years there have been a number of law enforcement organizations that have understood that the EDAAA covered all types of mutual aid and assistance. And since the Emergency Disaster Act doesn't require a written agreement, a number of cities don't have written agreements, even though they should, for certain types of mutual aid and assistance. And the goal of this webinar is to, by the end of it, everyone be able to sort of understand the two types of mutual aid and whether a written agreement is necessary or beneficial, or whether a written agreement is not necessary, depending upon the incident itself or the task performed. The type of incident itself dictates which statute applies. The EDA, for short, only covers events that have been declared or could be declared a state of emergency. And we're going to explain that definition here in just a second. And if the event is routine, recurring, or not an emergency as defined by the EDA, then a written agreement under the Interlocal Cooperation Act or the Mutual Agreements Act should govern. And that agreement should be in writing because that's what those statutes allow. So again, I know a lot of law enforcement agencies in the past, and rightly so, the definitions in this act are a little confusing, but
Kristen, may I interrupt? We've got a few people that are asking how this relates to fire departments. Is this more geared toward law enforcement or
I can,
this?
in terms of the Emergency Disaster Assistance Agreement Act, it does cover, if that act kicks in, it will cover public works, fire departments, emergency medical services, that sort of thing. But the other, what I was sort of tasked with was more just the use in law enforcement. So that's why I brought out the Mutual Aid Agreement Act. But the EDA would cover all types of governmental services as long as the incident falls under that act. So I hope that clears that up. And there, honestly, I know there are probably some other statutes that deal with emergency medical services and firefighting. That was not initially part of this. Now we have another, we're going to do the same symposium in August or same webinar at the symposium in August. And if needed or would be helpful, maybe we can expand it a little bit. So I guess at that point, if anyone thinks this isn't going to be that helpful, you're welcome to sign off.
I also have a question here. What declaration must be made to enable the EDA?
We are going to get to that in just a second, or at least the framework of what you need to do to enable it. So, but I want to make sure we all understand what falls under this EDA and what doesn't. So to understand that, you really have to look at the definitions from the statute. So bear with me. I'm not going to read through all of these, but these are sort of the most important. Aid. This is the one definition that I think has confused people over the years. It says aid is the same as assistance, except that aid is provided in an occurrence during any period of time when a state of emergency has not been declared. When you read that just by itself, it appears to be a very broad definition that basically anytime there's not a state of emergency, but you need some assistance, it should fall under this aid definition. But that's not right. The operative word in this aid definition is an occurrence. And we're going to define that in just a minute. So you'll see why this act is really very limited. So assistance, that just applies sharing of resources when there is a state of emergency. A disaster is when there's been a disaster declared by the governor or the president. Those are very specific. And here we go again with this use of the term occurrence. An emergency is an occurrence or threat of an occurrence, whether natural or man-made. So next, here's the most important definition in this statute that limits its scope tremendously. And it defines occurrence as the imminent threat of an event or an actual event and its aftermath, whether natural or man-made, that could lead to substantial bodily injury or property damage, and that could lead to the declaration of a state of emergency. So with that definition of occurrence in mind, if you go back to the, if you go back to the aid definition, the same as assistance, except that aid is provided in an occurrence. during a time when a state of emergency has not been declared. In short, what aid means is if there's not a state of emergency declared, but there is a natural or man-made threat, whether it be imminent or an actual event, that could lead to substantial bodily injury or property damage, and that could lead to the declaration of a state of emergency. So that's why this act is very limited in scope. Like examples of when, if there's not a state of emergency declared or a disaster declared, an occurrence would be something like an active shooter situation that could certainly lead to substantial bodily injury. Severe weather event could lead to substantial bodily injury or property damage. And both of those could, it doesn't have to, it just says could lead to the declaration of a state of emergency. So if there are any questions about that, because that is the overriding issue that I want to make sure we all understand, that this EDAA is somewhat limited in its scope. And someone asked the question about resolution or how to enable the EDAA, and we're going to talk about that right now. If an incident qualifies under the EDAA, I left out one of my A's there, then the statute allows agencies to share resources without a written agreement. The EDAA itself is substantive and provides all the guidelines and the framework for an agreement. It doesn't have to be in writing. It is statutory as to what parties, responding and requesting parties' duties and obligations are. But again, to qualify under the EDAA, an incident must be, as we've talked about, a declared state of emergency or fall within the definition of occurrence. And then to get the statute moving or going in the event of an occurrence or a state of emergency, a request for aid or assistance must be made by an appropriate official or employee to the dispatch center of the responding party. Now, this is important because the statute does specifically state that it must be made by the appropriate official. So in your policies or even by a resolution, your city or town needs to consider who that appropriate official is. Is it the chief? And in the chief's absence, it's a deputy chief, it's a captain, you could do maybe 3 different ones. That's really up to the city, who that appropriate official is, or senior law enforcement official, I've heard some refer to it as. But that should be in writing, either in your police department policies or maybe even in a resolution. So the city is well aware of who has the authority to make these requests. You don't want just anyone and everyone, maybe every dispatcher, having the ability to make these requests, because you have to understand what the EDA applies to in terms of what incidents it does cover. And then, regardless of whether well, let me back up a step. You can also have a written agreement for emergency disaster assistance. You don't have to have one. The statute sets forth the framework. But if you want to make, your cities want to make any changes to that statutory framework, that needs to be in writing. If you're good with all the framework that's set forth in the EDA, no written agreements necessary. But if you change it in any way, revise the duties, obligations, anything like that, then that needs to be in writing. And the statute does provide that whether you have a written agreement or not, it begins, or the statute becomes enabled by the requesting party making a statement, whether it's verbal or not, that a declared state of emergency has been made, or the threat of an occurrence, and again, it has to fall under that definition of occurrence, is imminent or in progress or has occurred. If the state of emergency has been made, then you give sort of a general description of the occurrence or emergency. It should also include identification of the service or functions for which aid or assistance is needed, the amount of resources you may need, and an estimated time and place for the requesting and responding party to meet up. So really what triggers the EDAA is the event itself, assuming it falls under the act. And then you can follow the statutory framework, make the call, and follow each of the guidelines set forth there. And there's a few more, I believe. Yes. Under this act, every request for assistance shall be confirmed in writing, and that is a shall directly from the act, shall be confirmed in writing to the responding party or parties within 30 days of the initial request, and you have to keep records of those requests for assistance. So you don't have to send a written request the day your emergency is going on. You can just make a verbal call, but within that 30 days, there needs to be some paperwork clarifying what the occurrence was, what you requested, what was provided, and that record needs to be kept. The statute requires that they be kept. And again, and this issue comes back up with the request for assistance must come through the appropriate official. So the city and towns need to designate who those appropriate officials are. Now, in terms of the responding party, the response under the EDA, it's discretionary. You don't have to provide any assistance if you think it would not be in your cities, or your city would be unable to provide assistance and not keep your own city safe. It's not a mandated response. It just allows for the requesting party to request assistance and the responding party to agree to provide or not. If you do agree to provide, then there's some liability shifting that occurs and helps detail and explain who's responsible for what actions during the course of one of these events. So, and if the responding party is not able or not willing to provide the assistance, that city shall notify the requesting party, and again, it's a shall, as soon as possible. Let them know that maybe you have enough going on in your city that, especially if it's a weather event, that you don't have extra resources to share with them. But you should, or you shall, notify, give a response to the requesting party. And then this is what sort of the crux of the EDA does, is it establishes a scope of authority and details who will be liable when responding parties and the requesting party are working together at a scene of such an occurrence or a state of emergency. And in short, what it provides is that employees of the responding party have the same powers, duties, rights, and immunities as if performing their duties in their normal jurisdiction. Because again, as we know, city officers have their powers, duties, rights, and immunities as long as they're within their jurisdictional limits. Once they're outside their jurisdictional limits, they really don't have the authority. But if it's something that falls under the EDA, some major occurrence like this, then if they go outside their jurisdiction, the statute itself says that they will have all the same powers, duties, rights, and immunities as if they had never left their own jurisdiction. Now, for workers' comp purposes, under this act, the employees of the responding party will be covered by the workers' compensation insurance of that responding party. So if someone is injured during the scene, traveling to and from the scene, you will be responsible for that employee's workers' comp. Your workers' comp insurance will cover him or her, or any injuries sustained by any employees of the responding party. But now for liability purposes, it shifts. And it says that employees of the responding party who are performing duties at the scene are considered employees of the requesting party. And let's just stop there before we read the last part of that sentence. That would mean, if in more practical terms, if an employee of a responding party is on the scene of an incident, responding to the scene of the incident, and say there's a clear negligent, how about an accidental discharge of a weapon during that scene and someone gets injured. Under this act, that employee who was responding to the scene would be considered an employee of the requesting party. So anything that occurs at the scene, the liability will rest with the requesting party. However, during the travel to and from the scene, employees are considered employees of the responding party, of their normal employer. And I hope all that makes sense. It's, I know, confusing, but does anyone have any questions about this up to this point?
Don't see any at this point.
Okay, or is everyone just sleeping? Because this is very technical. All right, so then we go to, so if everyone, the biggest takeaway, let me say this, the biggest takeaway from this is, this part of the webinar is that only occurrences or declared state of emergencies fall under this Emergency Disaster Act. You cannot use that statutory or that statute to say or to provide any framework or authority for routine events or recurring events or non-disaster related events, you know, that aren't specifically defined under that statute. So if it doesn't fall under that statute, you're going to have some other written agreement if you're responding outside your jurisdiction, because again, you are only seen as within the scope of your employment within your jurisdiction, unless there's a written agreement in place saying between two cities, city, county, that they are sharing resources and certain duties and obligations can be performed by the city or the county to sort of the mutual advantage of each.
I
So,
have questions here.
yes.
If it's all right to interrupt you. First question, I have three actually. So if Anna from Happy Town goes to Party Town and gets shot while on the scene in Party Town, who pays the workers' compensation?
Well, it would depend upon, is this an event that falls under the Emergency Disaster and Assistance Act? If it does, if it's, again, a state of emergency or an occurrence, then the responding party will be covered, or the responding party will cover their own employee. And the requesting party would recover or cover the requesting employees that are at the scene. Now, if it's not for something under the EDAA, then really there should be a written agreement specifying who would cover that employee. It just makes it very clear if we get that in writing. For practical purposes, and again, I would throw out that it seems like my understanding would be that the responding party would always cover their workers' comp employees. But again, that may be an issue that's under the actual PEP policy. And I know there's some people in the room out there that are in the claim section of PEP. If anyone knows or has a better answer to that, let me know. If it's under the EDA, then the responding party covers their own employees.
We have another question. Active shooter events, are they considered EDAA?
I think they could be, because again, the definition of occurrence, which includes the imminent threat of an event, natural or man-made, that could lead to substantial bodily injury. And clearly an active shooter event could lead to that. And so I think, in my opinion, that type of occurrence does fall under the act, an active shooter. Heather, was there another question before I move on?
The other question was related to the previous question, that you would be required to have a mutual aid agreement at that point.
Can you ask that question again, please?
Yes, it was talking about Party Town and Happy Town.
Okay.
If workers comp, well, there's two facets of this question. The first facet is, if the workers' comp is supposed to be paid by the other entity, how can they recover the costs from the entity they're assisting? And then also, in order for everyone to be made whole, would they have to have a mutual aid agreement?
Well, I think two comments on that would be, I'm not exactly sure what made whole would be. And herein lies the benefit of having a written agreement when you're responding to, like, Happy Town is or Anna Town's responding to Happy Town, if I have those right. For say it's a barricaded suspect. That's not going to fall under the Emergency Disaster Act, because there's no real threat of substantial bodily injury or property damage, and no way that such an event like that could be declared a state of emergency. So if it's, again, just an example, a barricaded suspect, and one town Happy Town needs assistance from Anatown. Anatown sends people over. They're outside their jurisdiction at that point. So without some written agreement in place under either the mutual aid agreement or the Interlocal Cooperation Act, there's really not any authority for that person to be performing those duties outside of their jurisdiction. And again, this is why what we were getting to in these types of events, why written agreements are absolutely necessary. You cannot rely upon the EDA if it is a non-disaster related event. Did that answer those questions? If anyone has any follow-up, please.
There were no follow-ups.
Okay, of course. Oh, there were not, or there were?
I'm sorry, there were no more follow-ups.
Okay, okay, great. I just didn't want to miss any questions from anybody. And now I was turning to just what we've sort of been talking about. How do you know what governs these non-disaster related events or a recurring need for sharing of law enforcement resources? And I guess trying to make it more practical, some examples of maybe these types of events would be one city has a canine unit, maybe a criminal apprehension dog or a drug dog, and another one doesn't. And they share those resources. Or maybe a special response team of some type that one government entity has and the other one doesn't, but you want to share those resources. And maybe because I know how hard it is right now to hire police officers and staffing is low, I understand that. And we all want to be good neighbors and help out as much as we can. So you could even craft a written agreement that, you know, would cover the sharing of resources. You know, if one entity is short for that day, they don't have the number of officers needed to protect the city. But again, those would have to be in writing under a written agreement, because we're back to the authority given to these officers by statute is only within their jurisdiction, or in some cases a mile outside, but generally only within their jurisdiction. So if you're going outside your jurisdiction to help with something that doesn't fall under the EDA, you need a written agreement explaining how that is going to work. And really, they can be drafted under either one of these enabling statutes that we talked about earlier. The first one is the Mutual Aid Agreement Act, and the other one is the Interlocal Cooperation Act. I think the preference would be, just to make it simple and not confusing, that you call the agreement an interlocal agreement. We don't call it a mutual aid agreement because that crosses over again into the name of the Mutual Aid and Emergency Disaster Assistance Act. So in order to sort of understand what type of incident we're dealing with and whether we need a written agreement or not, if a written agreement's required, I would refer to it as an interlocal agreement. And we are in the process of drafting a template for an interlocal agreement to cover the sort of routine, non-emergency, recurring sharing of resources. I've been sending it. MTAS and myself have both been looking at it. They've made some suggestions, and I just need to sit down and pull all that together. I hope to have that out by next week. And I also wanted input, and I wanted to listen to what people's questions are from this webinar to see what cities really needed in these written agreements and what would be most, would help them the most. So these written agreements, if it's not an emergency disaster, you need a written agreement to go outside your jurisdiction and exercise your duty or perform any of your duties. And that written agreement, what we'll call an ILA, must be endorsed onto your liability policy. Because, well, two things. Legally, your officers don't have authority by statute to go into another jurisdiction just to perform, sort of normal routine law enforcement duties. But PEP, as the insurer, also needs to know what they're insuring and what the cities have agreed to. Now, again, each city can agree to very different things. They can be very limited. The agreement could provide that you're only sharing a K9, or you're only sharing the SRT, but it can also be very broad. Regardless of what it is, it needs to be in writing, so that way your liability carrier can understand what they need to defend, what they don't, and what they're covering. So it's almost twofold with if it's a non-emergency or non-emergency disaster situation. You need it for legal compliance, to allow them to go outside their jurisdiction, and you need it so it's endorsed onto the policy, and PEP understands what they're insuring and covering for liability purposes. Does anyone have any questions on that? I know that's quite a bit. Okay. And here was just sort of the takeaway from what we've just been talking about. When is a written agreement required? And there's really two situations that a written agreement is required. And that is when the sharing of law enforcement resources for recurring, routine, or non-disaster related events. Just the short staffing, the a county needs the city's help at the jail because they don't have tasers. I know that happens sometimes, and the city will go over there and help with an inmate. Those types of sharing of services need to be spelled out in a written agreement. And that same written agreement would also discuss who is responsible for the workers' comp, who's responsible for the liability at the scene when they get there. I mean, it can be structured many different ways. It just depends upon how each city wishes to structure it. So if it's not an emergency, disaster and assistance occurrence, or a declared state of emergency, if you're sharing resources, you need a written agreement. Best called an Interlocal Agreement Act, or Interlocal Agreement, sorry. And then the other time a written agreement would be required is when a city or a town has decided it does not want to follow all the dictates under the EDAAA during an applicable event. So, for example, there's been that workers' comp issue. And under that EDA, the employee, the workers' comp coverage sort of moves with the employee. If you And that's what the statute provides for. If you don't want it to work that way, if you want the requesting party for the employee to be under their workers' comp, then that would need to be in writing, because that's not what the statute allows for. So if you want to change any of the dictates under that act, that would have to be in writing, and again, also endorsed onto the policy. And again, that's for legally and PEP. Legally, again, you can't go outside your jurisdiction without some authority. And secondly, the PEP, your insurance carrier, needs to understand what shifting of liability, workers' comp, what shifting is occurring between these cities. So in the event a lawsuit gets filed, you can turn to your written agreement and it should spell out which city is responsible for the particular negligent act that's being alleged. And again, the written agreements, we've got a good draft of a interlocal agreement that tries to cover almost any scenario, I guess, that I could think of. And I'm sure there's plenty of others out there, but this template or draft of the ILA that we're going to get up on the website and get it out to people to use is just a template. That's all it is. It's a draft. The cities can change the wording, can change what they want covered under that act, under that agreement. But the best advice would be for these interlocal agreements to try and be pretty specific and itemize the best you can what resources you're sharing and how the liability would shift back and forth. And again, the example we'll put up is just that. It can be modified however the city, your city attorney wants to. But that is by far sort of the best practice would be to have anything not falling under the EDAA. If you're going to share resources, it needs to be in an ILA, interlocal agreement.
So we have a question to clarify.
Okay.
Responding agency is responsible for their employee. Once they are on scene, the requesting party becomes responsible under both EDAA and reoccurring events.
No, I don't think. Let me back up again. With the EDAA, assuming it's an occurrence that falls under the EDAA, workers' comp, the workers' comp follows the employee. So the employees of the responding party will be covered by the workers' comp insurance of that responding party. So if the Happy Town employee goes to the other town to help in an event that falls under the EDA, then the responding employer would cover the workers' comp of that employee, and that's by statute. Now, if it doesn't fall under the EDAA, there needs to be a written agreement as to whose workers' comp insurance would in fact cover. Because if there's no written agreement, it is sort of thrown out there into, well, we sent an employee to help you, you should be responsible for the injuries that occurred. But do you always want to shift it like that? That would mean that anytime you requested help, you're going to be responsible for any injuries that come from, the responding parties. So it seems to me like it would be the easiest just to have the workers' comp insurance sort of follow the employee. But again, I sort of throw that out to PEP and their workers' comp, the policy itself, how exactly that would work. But it certainly would need to be in a written agreement, how you're shifting it one way or another. And I'm assuming if you decide to shift it at all, it's okay as long as it's in a written agreement and endorsed onto a policy, so everyone understands who's covering that particular employee. And I hope that answered that question. That's a little bit of a tough one. All right. Just real quick here before we wrap up, and if there's any other questions, I'll be happy to take them. But some other sort of best practices. We've talked about having a written agreement and when you need a written agreement. It is also encouraged and is actually strongly recommended that your written policies in your police department, or that they reflect, even if you need to do them in the fire department as well, if you're sharing fire department resources. It should sort of define the basis for the response and the appropriate official on who can request a response. And again, we're not talking about under the EDAA so much. That time we're talking about just whatever that written agreement says, make sure it's clear in the policy, so everyone understands who can request assistance and how the liability is going to shift and what scope of services are being covered. And again, I mentioned earlier, if the event does fall under the EDA, you also need to have in your policies or a resolution who is the appropriate official, and it can be, a list of several under that particular act to make the request. Because again, we don't want everyone that's part of the police department from top to bottom to be able to request assistance. You really need to be able, or you should narrow that scope down. And then make sure, again, you're sort of reviewing all your requests for assistance and aid, preferably under your written agreements. You're going to have a lot more of those than you are under the EDA. And just make sure that it's mutually beneficial for both cities. Again, we want to be good neighbors and help everyone out, but just make sure that, again, it's mutually advantageous for both governmental entities. And the last thing, the interlocal agreement that we'll have up and you can review and use and revise as needed. It would need to be signed by the mayor, city manager, whoever sort of the CEO of the city is, not just by the chief of police, but the city manager or mayor as well. That is really all I have, unless people have other questions. We sort of used up that whole hour rather quickly.
It does go by fast. We do not have any other questions. If anyone does have any, go ahead and put them in the Q&A and we'll be happy to address those. I got a question. Will we be emailing the slides? Yes, we will be sending out in two formats. We'll be sending out the PowerPoint in a PDF format, and I will also be sending out a link to this video presentation for you to share with other people within your entity that may need to hear this information. So we should be good with that. I'm not seeing, excuse me, Judy Housley would like to say just a very big thank you, Kristen. This is a very complex topic and you explained it very well. Thank you so much.
Thank you, Judy. I appreciate that. And I appreciate everyone that's helped me sort of work through this and put this together. We're revising the loss control guidelines as well. So we should have everything in nice order by next week, that people can actually use it. Some of them may have already circulated a little bit, which is fine. Again, the inner ILAs are really need to be individualized between cities. And if anyone ever has any questions, you know where to reach me. My email and number is on the front of the PowerPoint. I'm always happy to help or answer any questions that I can. And Heather, I think we're doing a similar thing at the symposium in August, right?
We will. I was just gonna, first of all, thank everyone for joining us today. We currently do not have any new Partnering for Success webinars scheduled, but the 2023 Risk and Insurance Symposium will be August 23rd through 25th. We will be covering this topic again, maybe a little broader in scope for those of you who are looking for other information. But this will again be held at the Cool Springs Marriott in Franklin, and you can register now. Registration is open on our website. Kristen, do you have any parting wisdom?
No, just thank everyone for staying awake through this very technical sort of information. It's not that exciting, but it's important. It's very important that we all understand how these acts work together to, best protect our cities.
Well, we appreciate everyone's time and look forward to serving you in the future. Everyone have a good day.
Thank you.